Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson, along with Maynard Nexsen attorney Jennie Kluvieri. It's good to see you, Jennie.
Good to see you, Tina.
Well, we have another lawyer with us today. It's Michael Parente. He is a white-collar defense attorney at Maynard Nexsen. Good to see you. And he represents a variety of businesses facing investigations, regulatory actions, and compliance issues. And he's here to talk to us about the intersection of protecting confidential information or trade secrets and the use of AI in the workplace.
Yes, Michael, thank you for joining us today. The employment team often works with the white collar team on issues that are partially employment, partially white collar. And this is one of those areas where our practices intersect. And we have the opportunity to work as a team on these issues for our clients. Michael, employees are using AI more and more in the workplace, both at their own discretion and at the push of their employers oftentimes. How does the increased use of AI tools pose risk to confidential business information from a white collar kind of standpoint?
Sure. Thanks for having me, Jennie and Tina. One of the biggest issues that we're seeing with the use of AI, like ChatGPT, for example, is you lose control over the data and information that's put into those systems. So you can type a prompt into these AI systems. You can also upload images and files and documents and recordings into the systems. And once they're uploaded into the systems, the user and the employer really loses control over that information. And it's very hard to recover it once it's uploaded into that system. So it might be tempting for employees to use these platforms to make their work more efficient and automate some tasks for them. But by doing so, they may be putting their employer at risk by uploading sensitive and confidential information into those systems. For ChatGPT, for example, is called an open AI system. And what that means is that the AI uses the information that's uploaded by you and by all the other users to train the AI model to continue learning and continue to be able to give you answers to your questions that you put in. So it's taking your information, it's saving it, and it's using that for future answers that could be coming from your competitors, that could be coming from others in the industry that are now getting results for their prompts based on your information that you're uploading. So it's a way that the employer kind of loses control over where that information goes once it's uploaded to these systems.
So employees can use AI tools and misuse it inadvertently. They might not even really know what they're uploading or how much it's being held on to, or they could do it intentionally and leak that confidential information. What kind of legal exposure are we talking about for the employer?
Sure. So, and that's a great point. Certain tools like Zoom, for example, have built-in summary options where it records your meeting and it'll give you a transcript or it'll give you a written summary of your meeting. But that recording stays inside of ChatGPT or inside the AI system, and it has access to that information. So that can cause some liability on, or can bring some liability on the employer's side. One of the main things from my perspective on the white collar side is False Claims Act liability. We deal with a lot of government contractors and employers that have government funds that they're using, and those contracts require a certain level of cybersecurity. The use of these open source AI systems would almost certainly violate those cybersecurity protocols in all instances. And there's been some allegations brought that you're representing to the government that you have these cybersecurity measures in place, when actually that is not true, and you're submitting a false statement to the government. And the government has gotten large, tens of millions of dollars in settlements based on these types of allegations recently. Just this year, there have been 3 or 4 different settlements that, $9 million for one, $11 million for another, where companies have certified to the government saying that they're complying with the various regulations and cybersecurity protocols, when in reality, their employees or what was happening in the workplace did not comply with those. So that can be a major form of liability. We're seeing in the False Claims Act space, we're seeing a definite uptick in these types of allegations and these cases being brought, and there are significant penalties that employers are incurring because of it.
So, Michael, you raise an interesting point about employers making these certifications to the government about their security measures that they have in place. we are seeing from the employment side a bunch of employers just beginning to think through the issue of should we allow AI in the workplace? And what I'm telling them is it's there already. Your employees are using ChatGPT. They're using other open source AI tools. And if you're not getting out ahead of it and educating them on appropriate use and that type of thing, it's going to become an issue for you. So it sounds like this is another kind of context in which, and a very important one, in which employers can maybe have their heads stuck in the sand and their employees are out there potentially creating issues by using these AI tools. So very interesting. Michael, I want to ask you, kind of in keeping with that, what proactive steps you think employers should take in the workplace to prevent AI-enabled corporate espionage and insider threats?
Sure. So I think one of the first things that employers need to look at is implementing a policy that governs the use. It's one of the first things that an employer can do to protect itself, and through that also educate its employees about the proper uses of these systems. I think employers should also, be training their employees on what are proper uses of AI or not. A lot of, especially younger people, may be using, ChatGPT on their phone, which might be a personal device. But if they're uploading sensitive information on that, there could be implications for the employer. So training on those types of things, I think, is especially important. Employers can also take steps to monitor use in the workplace on company-owned devices to see which employees are using it, what they're uploading, and things like that, and could even block, certain websites like ChatGPT or things like that that would violate their AI policy. Some of the AI platforms also allow you to change the settings on what is retained or not. So on certain platforms, you can turn off the ability for the platform to retain data and use that data to train itself later on. So that would be a good step if AI is allowed to being used to protect your information. And then finally, I'm seeing more and more employers that are creating their own closed AI systems, which means that it is usually it's a proprietary software developed just for the company that is trained just on the company's data, that only has access to the company's data, may or may not have access to the internet or other sources of information. And it is really just a tool that's used within the company on company data and is controlled by the company as a way to protect that data going into it.
And for a lot of companies that haven't really taken the precautions yet to minimize these issues by training their employees, preemptively, it gets to a point where, okay, something has happened. This is bad. And that's when they call you, or maybe they'll call you, Jennie, and say, what now? What do I do? So what is the employer's first step when they've realized that confidential information is leaked?
So this is one of the areas where I think those proactive steps are so important, because once there is information that is lost or uploaded into these systems, it is incredibly difficult to track it down, to figure out where it went, what happened to it, who has access to that data now. It's unfortunate, but once it's uploaded, the damage is kind of done. One example of this is a platform called DeepSeek, which is a Chinese platform that is run out of China and owned by Chinese companies. And because of the cross-border issues with China and everything, it's very difficult to understand what is happening to that data once it goes not only into the system, but across borders. Certain countries have banned the use of DeepSeek altogether. I think we're seeing a lot of companies ban its use, but places like South Korea and Australia, as a country, have banned the use of DeepSeek because of these issues and because of the threat of data getting out and going, potentially into foreign actors' hands or things like that.
Michael, how are federal agencies like the DOJ and the FTC responding to AI misuse in the context of fraud and, of particular interest to employers, trade secret theft?
Sure. So starting with trade secrets, the DOJ can bring criminal charges based on trade secret theft. There are criminal penalties provided for in the statutes. They don't bring criminal cases in every instance, but especially when it deals with things like national security or state secrets or technological data going into foreign hands. That's instances where we're seeing DOJ get involved a little bit more in those cases. On the fraud front, AI is making it a lot easier to commit fraud, unfortunately. We've all heard of deep fakes, where there are recordings or videos or voices on telephone calls that may sound like it's coming from you, but is really a computer. And I may, give over sensitive information or financial data or any number of things. So that's an area that DOJ and FTC are really cracking down on, is this AI generated fraud. It's just becoming so easy for bad actors to make this kind of material and to get access to your information and financial data. It's also being used by DOJ to combat some of this. So you can use AI to detect other AI. And that is one tool they're using to try to get at that. I know the last administration made it a priority to pursue people that were taking, disruptive technologies, AI, and exporting it outside of the country. It'll be interesting to see what this administration does with enforcing that type of theft, but was certainly a priority of DOJ and FTC to crack down on this type of misuse.
So Michael and I have litigated a number of trade secrets cases together over the years. And I think the point is interesting about the DOJ getting involved in cases. And we have actually had that happen. And to Michael's point, if you've got federal contractors who are manufacturing or handling very sensitive data for the government, and in one of our particular matters, there was an former employee who left with a bunch of trade secret information and went to work for a Chinese-owned company. The government got very interested in that. So again, kind of coming full circle here at the end of our podcast to how the white-collar practice really intersects with employment, especially in these types of contexts.
Absolutely. Well, I was going to ask about that, the way that employment law does intersect with white-collar and government investigations. What are some other types of matters that you might end up having to collaborate on and seek Michael's counsel or the rest of his team?
Sure. So unfortunately, at times when we're involved in an employment case, we can come across during the discovery process some data or information that employees may have on their work computers that is illegal to have. Unfortunately, at times we run across things like child pornography, which is a very sensitive matter for employers and must be handled with the utmost care. And our first call in situations like that is, of course, to our white-collar team. Michael is basically on speed dial for me, because you never know when you're involved in an employment matter or you're in an investigation when a sensitive issue like that might come up. I've had to reach out to the white-collar team for instances of potential criminal conduct in the workplace, just overall, whether it's, financial crimes or things like that, down to, I guess it's not so white collar, but down to things like, assault in the workplace and especially involving underage individuals. So really lots of different ways that our practices can intersect. And as I said, we work very closely with the white collar team to make sure that our clients are protected and understand their risks, not only from the employment standpoint, but also on the criminal side. And those can be some very substantial risks at times.
And Tina, on the other side, we may work with the employment team. For example, if I have a False Claims Act case where there's a whistleblower who's making allegations against the company, there are retaliation protections built into the False Claims Act, and they can bring separate claims for retaliation. And so we may reach out to the employment team on how best to handle it to make sure that they're not being retaliated against. If there is a retaliation claim, that is something that the employment team handles regularly. So we'll work together in situations like that also. Interesting.
Well, just another benefit of a full service law firm, I suppose, right?
Absolutely.
Well, thank you both for being with us today. Thank you, Michael, for taking the time for the Work This Way podcast. Appreciate it. And we will see you next time.